Hello, welcome once again to Lehto's Law. I'm Steve Lehto. Today we're going to talk about whether or not you can flip off the cops. Can you flip off the cops? What I'm talking about, of course, is a gesture that is universal, believe it or not, in its recognition. And I'm not going to do it on camera, but when you hold your hand up like this, but you don't use that finger, that finger, that finger, or your thumb, and you simply have the one finger extended, and you often do it with your hand facing that way towards somebody, and you do it as an expression often of your opinion of the other person's driving. However, some people are tempted and actually do make that gesture towards police officers to let the police know what they think of them. And you also will occasionally hear of this being done by somebody who is famous or someone who's being harassed by the press or someone who's just wanting to show some displeasure towards somebody else, and they'll make this gesture. So believe it or not, there's actually been quite a bit written about this, and I highly recommend if you've got some time to kill and don't mind reading stuff that reads a little legalish. There is a wonderful article that I'm going to be basing pretty much everything I talk to you about right now on, called Digitus Imputicus: The Middle Finger and the Law. And this is written by a law professor named Ira Robbins, and he is the Bernard T. Welsh Scholar and Professor of Law and Justice at the American University, Washington College of Law. And this guy's got credentials. He's got a JD from Harvard, and his undergrad is from the University of Pennsylvania, another fine school. And he actually wrote a very lengthy, I think like 80-page article on the legalities of flipping somebody off. And when is it legal? When is it not legal? Or is it illegal? And it turns out a lot of it depends on the context. But a lot of this has been ruled on by the courts. And I remember years ago reading a story in the local paper in Michigan here about a guy who was driving along one day and he saw a police officer and he flipped the cop off, and the cop pulled him over and wrote him up for something. And I don't recall if he wrote the man a ticket for something else, but anyways, he filed an action in essence saying that he was being targeted because he'd made this gesture towards the police officer, which the police officer, then characterized as an obscene gesture. And I recall that it got hashed out in courts here. I don't know if it's a reported case or not, but it got thrown out because the judge just basically said, hey, look, we have this thing called the First Amendment, and you've got a freedom of speech. And gestures can be considered speech. And the gesture he was making, he was just basically expressing his displeasure with you. Why can't he do that? If I can yell at a cop, hey, I don't like you, why can't I flip that cop off? So we'll talk about this, but again, I want to thank Professor Robbins. This article is absolutely wonderful. I will put the link below so you can read it as well if you want to. But he starts off by pointing out that the middle finger is one of the most common insulting gestures in the United States. The finger, which is used to convey a wide range of emotions, is visible on streets and highways, in schools, shopping malls, and sporting events, in courts and execution chambers, in advertisements and on magazine covers, and even on the hallowed floors of legislatures. I can think of a few album covers I've seen it on for recording artists as well. Despite its ubiquity, however, great word, ubiquity, a number of recent cases demonstrate that those who use the middle finger in public run the risk of being stopped, arrested, prosecuted, fined, and possibly even incarcerated under disorderly conduct or breach of peace statutes and ordinances. This article argues that although most convictions are ultimately overturned on appeal, the pursuit of criminal sanctions for use of the middle finger infringes on First Amendment rights, violates fundamental principles of criminal justice, wastes valuable judicial resources, and defies good sense. Indeed, the U.S. Supreme Court has consistently held that speech may not be prohibited simply because someone may find it offensive. Criminal law generally aims to protect persons' property or the state from serious harm. But use of the middle finger simply does not raise these concerns in most situations, with schools and courts as the exceptions. So we're talking about, you flip somebody off, are you going to get in trouble? And if so, why? And should it happen? So he starts off by pointing out that a man named Robert Lee Coggin got some fame in 2003 when he allegedly gestured with his raised middle finger as he passed a motorist on a Texas highway. He was convicted of disorderly conduct and fined $250. During the next year, Coggin successfully challenged his conviction, and it cost him $15,000 in legal fees to do it. But a Texas appellate court ultimately acquitted Coggin and left open the possibility that motorists could be prosecuted for using the middle finger gesture under Texas law. But that's only if the gesture was accompanying a road rage or reckless driving situation. So in other words, the gesture by itself is not actionable, at least according to that court. So he points out that and this is one of the fascinating things, if it's speech, if the gesture is speech, then the question is, what exactly is somebody saying when they flip you off? Like I said, the situation I think of most commonly is someone is expressing their displeasure at someone else's inept driving, okay? The times where I'm tempted to use that gesture is usually when I see someone do something remarkably stupid, like run a red light or almost kill me. And those people deserve it. So the middle finger gesture serves as a nonverbal expression of anger, rage, frustration, disdain, protest, defiance, comfort, or even excitement at finding a perfect pair of shoes. And that is a quote from a case, which I'm not going to get into here. But the gestures appeared on streets and highways and schools, shopping malls, concert venues, stadiums, courts, and execution chambers. As you can imagine, a guy who's about to get executed might flip off the guy who's about to kill him. What do you do? Stop the execution so you can charge the guy with that? Also, it's been seen in advertisements, magazine covers, and even on the hallowed floors of legislatures, although its meaning has remained relatively constant over time. The middle finger gesture is like the F word and has become part of the American vernacular, and in the process, it's becoming less and less taboo. The stories that we were talking about illustrate the alarming fact that individuals who use the middle finger do run the risk of arrest, prosecution, fines, and possibly incarceration. We'll get to one of those. Despite the fact that gesture often serves as a non-violent means of releasing stress or expressing frustration. And that's true. You know, most of the time there's a weird traffic incident, somebody almost kills somebody, and the person in the other car flips them off, and they both go their own way. That problem resolved. That's the end of it, unless you call the cops and have someone arrested. So, you know, that does often not lead beyond that. The criminal law generally aims to prohibit serious harms to persons, property, or state. Nonetheless, our laws have criminalized acts that go well beyond fundamental offenses to include behavior that threatens highly intangible harms about which there is no genuine consensus. And that's one of those things where people often talk about, you know, what's the corpus delicti? What's you know, who's been harmed by something, you know? And I've heard people say, well, I'm speeding 5 over, who am I harming? Well, that's one thing. If you flip somebody off, who are you harming? Are you harming them? You know, I've heard people say if you flip somebody off, someone else might see it. Are you harming them? Bystanders. Innocent bystanders were harmed because you flipped somebody off. Who knows? So, interestingly, the professor here goes into a great history of how far back the flipped middle finger goes. And what's sad is there's a really dumb story that goes around about how it started with a bow and arrow fight at a place called Agincourt in France. And that's not true. It's a Snopes kind of story. It actually goes back much further than that. The weight of historical evidence says that the middle finger gesture actually originates more than 2,500 years ago. And for instance, it appears as far back as ancient Greek texts. In one called The Clouds, Aristophanes used the middle finger gesture as a phallic symbol. And in 330 BC, the book Lives of Eminent Philosophers referred to the middle finger gesture. A reenactment of a meeting between Diogenes and Demosthenes has Diogenes expressing his dislike of the pompous orator by extending his middle finger and stating, "There goes the demagogue of Athens." So the middle finger has been around a long, long time. Probably about as long as humans have had middle fingers. But using it as that form of a gesture, likewise, goes back quite far. And one of the things that the professor points out over several pages is all the different cultures that recognize this. Because as you can imagine, in ancient Greece, they didn't speak English. Surprise, surprise. You know, the people in the Bible also didn't speak English. I know the Bible's in English, but they weren't talking English. And so the fact that cultures and societies around the world have recognized and used this as a gesture that expresses these things we've talked about shows that this is a universal gesture. And it's kind of like waving to somebody. Waving is a universal gesture also. Handshakes are not quite universal, but again, recognized across many different cultures. And so it's interesting how these things can do that. So the fact that we're looking at the flipping off of somebody as being verbal speech, it's not. We're communicating something, and communication of ideas can be protected as quote unquote speech under the First Amendment. But in reality, it's not speech. But it's an interesting thing. So the middle finger and the First Amendment is the next section of the paper. And he gives the example of a woman who flipped off a crossing guard near her children's school. And the crossing guard got the woman arrested. And when she's brought into court, her name is Laura Benson, she got lectured by a judge who basically said, you need to have more respect for crossing guards. But that one didn't get litigated all the way to the Supreme Court or anything. But he points out that the First Amendment, as I just said, doesn't just protect speech in the purest sense. Speech is words that I'm speaking. And obviously, it protects the written word, and it protects other forms of expression. So, for example, the court has extended First Amendment protection to nonverbal expressive acts such as flag burning, sit-in protests, or even displaying a U.S. flag with a peace symbol affixed to it in protest. And I presume that's probably in violation of law. It says you can't deface an American flag. So the court always analyzes these things under the concept of the First Amendment, and that makes complete sense. So the first question then becomes is if, in fact, flipping somebody off is a First Amendment protectable form of speech, you have to look at the other things that are not protected. So one example is fighting words. And fighting words are defined by a case called Chaplinsky versus New Hampshire, where the court said that words which by their very utterance inflict injury or tend to incite an immediate breach of the peace are fighting words. And they talked about the context in which it occurs, but they didn't give explicit guidance on how to determine what fighting words exactly were. But the courts never directly addressed whether the middle finger gesture constitute fighting words, but it has decided a case involving an individual's use of the word F with 3 letters following it. So I'll refer to that as the F word, okay? In Cohen versus California, the court overturned a conviction for disturbing the peace by offensive conduct, where the defendant was arrested for wearing in a courthouse a jacket that had the words on it, F the draft. And the court said, those aren't fighting words. Those are just a man expressing his political opinions regarding the draft, presumably. And so those aren't fighting words. And most people, I think if you said, hey, quick, how would you put into words the fact that someone's flipping you off? What are they saying to you? Are they saying something to you? Most people would say, yeah, that's F-U. The word you, Y-O-U. So the 4-letter word F and then U is what they're saying to you. And if that's not considered fighting words, then I think that gesture would be okay. The next question, of course, is being flipped off, is that obscene? Is it obscene? Because it has some kind of sexual connotation to it, if in fact it means what I just said it does. And so you can be arrested for obscene language in some certain circumstances. So the lower courts have ignored prevailing Supreme Court obscenity jurisprudence and issued rulings that violate the First Amendment. Sometimes when they convict people for yelling things out like, F you, asshole, to a public highway worker. And I apologize for using that word, but it's a quote, but also I don't think that's considered obscene these days. And so the middle finger gesture traditionally has been associated with male genitalia. And it undoubtedly retains its phallic connotation. But it does not fall in the current legal definition of obscenity. So it's not obscene to give someone the middle finger. And he talks about what the standards are for determining if something's obscene. There's a 3-part test in Miller versus California. And he points out that of the 3 prongs of Miller versus California, it doesn't meet any of the 3, let alone all of the 3. The question then is it profane or offensive? Because the history of the law of free expression is one of vindication in cases involving speech that many citizens may find shabby, offensive, or even ugly. It is firmly settled that under our Constitution, the public expression of ideas may not be prohibited merely because the ideas are themselves offensive to some hearers. But it's possible that some profane or offensive speech might cause you trouble. But he points out that most of that, again, doesn't rise to this level, or at least the making of this gesture wouldn't rise to this level. And he talks about, for instance, all the different places where they discussed this, including on episodes of Seinfeld, and apparently, I'm guessing, during the show Springer. Jerry Springer's probably had guests make that symbol or sign at him or at each other or at the camera. So here's the situation. Are there any places where it's not appropriate? Okay, so in other words, if you're out in public and you do it to another person, you're probably okay. If you're out in public and you do it to a police officer, he might harass you, he might give you a ticket or write you up for something, but you'll probably win that. It just might cost you some money. But yeah, if the police officer writes you up for that, it's harassment. But the question is, he points out it's cops, classrooms, and courts. So let's discuss cops first. Convictions for use of the middle finger often arise from its use in the presence of police officers. Through disorderly conduct or breach of the peace statutes and ordinances, police officers have enormous discretion in making arrests. They often use that power to arrest individuals whose offense consists of nothing more than displaying the middle finger. And he gives a bunch of examples. And he says, for example, disorderly conduct or breach of peace convictions have resulted from the following circumstances. A state trooper observed a garbage truck driver giving the finger to drivers, to other drivers, not the trooper, but to other drivers. An unruly bar patron who has been escorted out of a nightclub by a police officer gave the finger to the officer during a subsequent encounter. An officer observed a woman giving the finger to drivers who honked their horns when she hesitated at a green traffic light. Now, seems to me the honking in that situation is perfectly appropriate. Her flipping them off, maybe not so much appropriate, but the response is you flip her off back. It's an arms race or a finger race. Take your pick. A university alumnus gave the finger and said F you to two officers in a university library. I guess it might depend on the volume. And a juvenile gave the finger and shouted, "You effer," to officers as he passed their parked patrol car. In all but one of these cases, the conviction was overturned on appeal. The Ohio Court of Appeals upheld a disorderly conduct conviction, distinguishing non-personal language not directed toward a particular officer from offensive language specifically directed toward a particular officer. The court reasoned that the defendant sought out the officers and continued to use the abusive language and the middle finger gesture even after officers asked the defendant to desist. That did not go to the U.S. Supreme Court, however. That was simply an Ohio Court of Appeals case. Case law and commentary, as well as practicality, suggest that society should expect police officers, based on their experience, training, and legal obligation to preserve the peace, to exercise restraint and tolerance when faced with criticism and offensive speech. And that's the thing, police officers have got a tough job, but guess what? You signed up for it. And later on, courts have addressed whether or not officers should be held to a higher standard than the average citizen when faced with verbal criticism or offensive speech. Justice Powell of the Supreme Court addressed the issue in a concurring opinion and said, a properly trained officer should exhibit a higher degree of self-restraint than the average citizen would exhibit in similar circumstances. Thus, the officer should be less likely to react violently to offensive language or criticism. Later on, that view gained support in a case called City of Houston versus Hill, when Justice William Brennan for the majority wrote that a police officer should exercise a higher degree of restraint than a private citizen when faced with vulgar or offensive language or behavior. The court examined the constitutionality of a municipal ordinance that proscribed interrupting a police officer in the performance of the officer's duty. Now, that did not go into whether or not someone can flip off the cops, but that went into whether or not, if you walked up to and started trying to interact with police officers who didn't want you interacting with them, do they have the right to either stop you, or do they have the right to charge you with something for interfering with them if you're simply speaking, arguing, or yelling at them? Which is something I've spoken about before. When you go up to a police officer and start screaming at him while he's trying to do his job, you might upset him to the point where you get written up for something. So you have to understand, and this is what the professor who wrote this article, Professor Robbins, says, is that the law is not completely settled on this. A flipping off of a police officer or the flipping off of a person and being charged has not explicitly been ruled on by the U.S. Supreme Court. So until they actually rule on, yes, you are allowed to flip off a cop, or no, you're not allowed to flip off a cop, we have to speculate on what they might do based on lower court rulings and what they've ruled on cases that are related and how they might, work those things out. But he does point out that the state of the law is this. State and federal courts in the U.S. are divided on the extent to which officers should be required to tolerate offensive speech and the extent to which the middle finger gesture is protected by the First Amendment. Some jurisdictions have adopted the reasoning of Hill and Justice Powell's concurrence in Lewis, finding that it is reasonable to expect police officers to abide verbal criticism. For example, the U.S. Court of Appeals for the Second Circuit held that an individual's right to criticize the police without reprisal is protected by the First Amendment, and that speech directed at police officers will be protected unless it rises far above mere inconvenience, annoyance, or unrest. In a case in which an individual gave the middle finger to a police officer, the Ninth Circuit held that such expressions of disapproval of the officer's actions constitute protected speech, noting that police may not exercise the awesome power at their disposal to punish individuals for conduct that is protected by the First Amendment. But the Supreme Judicial Court of Maine noted that police officers must exercise the greatest degree of restraint in dealing with the public, holding that the nature of the experience, training, and responsibilities of police officers should be considered when deciding whether conduct amounts to fighting words. An Alabama court found that since officers encounter offensive language and conduct on a regular basis, and they are trained to handle potentially volatile situations without physical retaliation, words or gestures that might provoke an ordinary person to respond violently do not necessarily amount to fighting words when directed toward an officer. These cases do not hold that any and all speech directed toward a police officer is protected. Rather, they suggest that the fact that a trained police officer is involved in an encounter is an important consideration when determining whether an individual's conduct constitutes fighting words. In other words, a court might reach a different conclusion under the fighting words doctrine in a case involving an encounter between two citizens and a case involving a citizen and a police officer. So it's all stuff to keep in mind. And like I said, and he points out, the courts have addressed this differently over the years. He says that the best approach he's seen is illustrated by a decision of the Supreme Court of North Dakota, reversing the conviction of a man who, during a confrontation with police officers, gave them the middle finger and said, "Effing bitching cop, F you, F my ass, and you don't know who you're effing with." Finding that there was no evidence that the language or conduct tended to incite an immediate breach of the peace, based on testimony from several witnesses who said that they would not have reacted violently to the defendant's words and gesture, the court overturned the disorderly conduct conviction. The court noted that whether particular words are fighting words depend on the circumstances of their utterance, and the fact that the words are spoken to police is a significant circumstance. So that may have been different if he'd done that to an individual, but the North Dakota Supreme Court says, well, he did it to a cop, and they are held to a slightly higher standard. Now, he also writes, when it comes to mere use of the middle finger gesture, however, law enforcement officers should not have authority to make arrests for speech or conduct that rises only to the level of a minor offense or annoyance, because the First Amendment protects offensive, vulgar, or unpleasant speech. In the case of speech and gestures directed toward a police officer, the Supreme Court has stated that officers should expect to tolerate some offensive speech, and that their training and experience should prepare them to exercise a higher level of restraint than an ordinary citizen. Arrests for use of the middle finger in the presence of a police officer undermine the Supreme Court's steadfast recognition that the right to criticize the government lies at the core of the First Amendment. So he's pointing out that you ought to be able to flip off a cop. And you probably are allowed to flip off a cop. But a cop might arrest you for it and charge you with something, which you may then have to fight and work your way up the system. That's the current state of the law. I know people right now are saying, Steve, that's not a good answer. Well, no, but that's the correct answer. That's the current answer. That's what the answer is now. Okay, and until one of these cases makes it to the Supreme Court, that's the answer. The question is, what about other circumstances? One of the best examples he gives is if you're at school, a public school system. Okay, the First Amendment ensures broad protection of adults' public speech, but the U.S. Supreme Court has limited the speech rights of elementary and secondary school students on school grounds. And there have been a series of cases since about 1969 that have addressed significant things regarding student speech on campus. And he points out that a school's authority to punish student speech may not extend beyond school grounds, but they certainly can control it on the grounds. So it appears settled that when a student uses the middle finger on campus, school officials may either punish the student administratively or seek to sanction the conduct through the state's police power. And then off campus, they don't have that right. And one of the best things I think I saw was a kid who saw a teacher, not at school, but someplace out and about in town, and he flipped the teacher off. And the teacher went and complained to somebody at the school, and the kid got punished at school for what he'd done. And they said, no, you can't regulate that kid's speech off campus. So that's that. The final place we've got to talk to about this with respect to where you can and cannot use the middle finger is in court, in a courtroom. And using the middle finger as a gesture in a public place, Robbins points out, is almost always a valid exercise of free speech. However, that changes when you set foot in a courtroom. And I know people out there right now are some of them are getting very, very upset saying, why do laws and rules change within a courtroom? There's a good reason for it. As he points out, judges should have the ability to prohibit use of the middle finger gesture during legal proceedings because courts perform an essential public function, the administration of justice, and the integrity of which can be threatened when an individual behaves in a disruptive and disrespectful manner in a courtroom. Using the middle finger in court, especially when directed toward a judge or an officer of the court, threatens to inhibit the fair and efficient administration of justice, erode the authority and legitimacy of the judicial system, and jeopardize the constitutional rights of the litigants. And think about this, okay? You're in court, you're a defendant on trial, and you decide to flip off the judge. Now, you might think that's your right, free speech. It's not helping your case any. Don't you want the judge to be impartial? But there is also a thing about the judge has, the right to control what happens in his courtroom. And same thing if a person starts screaming or yelling or simply speaking out of turn. A judge has got to keep things under control. So, controlling how people speak, when they speak, what they, that's all things that fall within the jurisdiction of the judge. So, in order to prevent these harms from occurring, judges should have the authority to punish individuals who intentionally disrupt the judicial proceedings by giving the middle finger to a judge, jury, or an officer of the court. This authority is most often exercised through the power to hold individuals in contempt of court. The contempt power is, of course, an old and ancient authority, and it goes back many, many years. And so I'll give you an example. A Massachusetts appellate court overturned a contempt conviction where a woman gave the finger to her alleged abuser as he exited the courtroom after a judicial proceeding. The court found that the gesture was a single isolated event that was not directed at the judge, but rather at the person who the defendant claimed had beaten and threatened her. So the guy's being led out of the courtroom and she flips him off. And the judge, trying to be fair here, holds her in contempt. And of course that got thrown out on appeal because of what I just told you. So there are other examples where people have done these things in a courtroom, and depending on who they direct it at, they may or may not get in trouble for it. So a judge of the Court of the Common Pleas of Philadelphia ordered Walter Williams to prison at the conclusion of a probation revocation hearing. Williams registered his displeasure by saying F you to the judge, punctuating his statement with his middle finger. Much to Williams' further dismay, the judge found him guilty of 2 counts of direct criminal contempt and imposed 2 additional consecutive sentences of 5 months and 29 days, one for the language and one for the gesture. On appeal, the Superior Court of Pennsylvania found that Williams' behavior satisfied each of the elements of contempt, But because the gesture and accompanying offensive word have the same meaning and were used simultaneously, the court concluded that Williams could only be found guilty of a single count of criminal contempt. So that gets us back to what does it mean? I think we know what it means. If you want to get a verbal, like you had to subtitle it. That's pretty much what it means. But the conclusion that Professor Robbins draws is that most reported prosecutions for use of the middle finger involve a private citizen flipping off an authority figure, usually a cop, but sometimes a judge or a school principal. The U.S. Supreme Court repeatedly has emphasized that speech critical of the government deserves stringent and steadfast First Amendment protection. Courts have interpreted this sweeping statement to include direct verbal criticism and challenges to most government officials, as long as the speech does not rise to the level of fighting words, obscenity, or defamation. So flipping somebody off does not rise to that level. So as he ends, he says, in other words, if these days the bird is flying everywhere, it is a small price to pay for the freedom of speech that our Constitution protects. So to summarize even more narrowly than he just did, flipping off a cop, you're probably okay, although you might get in trouble for it, but you probably win it later. Flipping off somebody in school, if you are in public school, in elementary or middle school, possibly even high school, probably not a good idea. Off grounds, go right ahead if you feel like it. And in court, wouldn't recommend it. But again, if you feel that strongly about it, you can always litigate it later. So that's the law on using the middle finger as a gesture in America today. I will put the link to the well-written, wonderful article below. Questions or comments, fire them my way. Otherwise, I'll talk to you later. Bye-bye.